Great honor for us to receive him here as guest speaker and as judge for the final round of the Manfred Lachs Space Law Report competition. Dr. Tario Kusibi, everybody.
Your Excellencies, distinguished colleagues, ladies and gentlemen, it gives me great pleasure to deliver this address on the eve of the first Africa Regional Round of the 2012 Manfred Lachs Space Law Moot competition, organized by the International Institute of Space Law. And I should begin by thanking very warmly the hosts of this Africa Round, including the Aerospace Industry Support Initiative of the South African Department of Trade and Industry, as well as the Institute for International and Comparative Law in Africa and the Faculty of Law of the University of Pretoria. The timing of this auspicious event comes on the heels of several remarkable milestones witnessed during 2011, marking the 50th anniversary of the Legal Subcommittee, the 50th anniversary of human spaceflight, and the 50th anniversary of the Committee on the Peaceful Uses of Outer Space. Later in 2011, the United Nations General Assembly, in its Resolution 6671, adopted the 50th Anniversary Declaration. In the 50th Anniversary Declaration, which is annexed to Resolution 6671, the Assembly recalls the first meeting of the Permanent Committee on the Peaceful Uses of Outer Space, which was convened on 27th November 1961, and which facilitated the adoption of General Assembly Resolutions 1721A to E. By Resolution 1721A, the following principles were commended to states for their guidance in space activities: that international law, including the Charter of the United Nations, applies to outer space and celestial bodies, and that outer space and celestial bodies are free for exploration and use by all states in conformity with international law and are not subject to national appropriation. In Resolution 1721B, the Assembly, amongst other things, expressed its belief that the United Nations should provide a focal point for international cooperation in the peaceful uses of outer space, and also stipulated the first mandate for the registration of objects launched into outer space. 50 years after its adoption, this resolution is still highly relevant in the area of registration by providing the grounds for registration of space objects by states not parties to the Registration Convention. In the 50th Anniversary Declaration, the Assembly also recalls the entry into force of the Outer Space Treaty, which establishes the fundamental principles of international space law and reaffirms the importance of international cooperation in developing the rule of law, including the relevant norms of space law, and of the widest possible adherence to the international treaties that promote the peaceful uses of outer space. Among numerous truly impressive achievements, the Committee and the Legal Subcommittee have been instrumental in the development of the international legal regime governing the activities of states in the exploration and use of outer space, consisting of 5 treaties and 5 sets of declarations and principles on outer space activities. The Outer Space Treaty, together with other treaties on outer space, constitute the legal foundation for space activities today. In the 50th Anniversary Declaration, the Assembly acknowledges significant changes have occurred in the structure and content of space endeavors, as reflected in the emergence of new technologies and the increasing number of actors at all levels, and therefore notes with satisfaction the progress made in strengthening international cooperation in the peaceful use of outer space by enhancing the capacity of states for economic, social, and cultural development, and by strengthening the regulatory frameworks and mechanisms to that effect. In this regard, I bear witness to the efforts of the committee and the legal subcommittee to further advance the application of the legal regime of outer space and to promote capacity building in space law. In the context of discussions within the mandate of the working group on the status and application of the 5 United Nations treaties on outer space, the growing understanding of the provisions of the Moot Agreement, including the concept of common heritage of mankind, is now prompting a reflection and discussion process by some states on the possibility of becoming parties to the Moot Agreement. Likewise, the Working Group on National Space Legislation, relevant to the peaceful exploration and use of outer space, in concluding its final report, elaborated the text which shall be considered and agreed upon by the committee at its 55th session as the basis for a separate draft General Assembly resolution or an annex to the draft resolution on international cooperation in the peaceful uses of outer space. This text emphasizes the importance of appropriate means of ensuring that outer space is used for peaceful purposes and that the obligations under international law and those specifically contained in the United Nations treaties on outer space are implemented. Furthermore, in recommending specific elements for consideration by states when enacting regulatory frameworks for national space activities in accordance with their domestic law, no doubt, as appropriate, taking into account the specific needs of the state concerned, the text commends, amongst other things, that continuing supervision of non-governmental state activities should be ensured in the event of the transfer of ownership or control of a space object in orbit, as national regulations may provide for authorization requirements or obligations for the submission of information on the change in status of the operation of a space object. At the dawn of this semi-centennial period of space lawmaking, it is becoming increasingly necessary to ascertain if one should draw a clear distinction between binding and non-binding instruments, thus rejecting the use of instruments or measures which are not binding in the strict sense. Alternatively, one could consider certain non-binding instruments of a potentially evolutionary nature that do impact on the relationship between states in their interaction with one another, clearly in order to facilitate the development of subsequent treaties or even customary international law.